Once again, Justice Jackson didn't tell us. Well, because the administrative state does, in effect, constitute a fourth branch of government, an amendment of the Constitution was necessary to allow for it. No such amendment has ever been ratified or even proposed. Therefore, having, by everyone's admission, altered fundamentally the forms of our government, and having done so unlawfully, the administrative state must constitute, in the words of the Declaration of Independence, an injury and usurpation having in direct object the establishment of an absolute tyranny over this country, QED. Right? Don't have to be a justice of the Supreme Court to recognize that. Is this description too harsh? Well, not at all. The characterization of the administrative state as a form of tyranny is perfectly accurate. Tyranny can be defined in a number of ways. Everyone here, I suppose, should be familiar with what James Madison wrote in the Federalist number 47. Quote, "No political truth is certainly of greater intrinsic value or is stamped with the authority of more enlightened patrons of liberty than that the accumulation of all powers, legislative, executive, and judiciary in the same hands, whether of one, a few, or many, and whether hereditary, self-appointed, or elective, may justly be pronounced the very definition of tyranny." Well, in contrast to the form of government established by the Constitution, which carefully separates the legislative from the executive from the judicial powers in different hands, so as to create checks and balances against misuses of public authority, administrative agencies combine all three of these powers in the very same hands, eliminating checks and balances and therefore facilitating, if not encouraging, abuses and misuses. Thus, even if administrative agencies attempted in good faith to promote their arguably benign conceptions of the public interest, they would always remain tyrannical in principle, under the principle that Madison wrote in the Federalist Papers. And an apparently benevolent tyrant is no less a tyrant than an obviously malevolent one. Moreover, being tyrannical in principle, administrative agencies are capable of turning from benevolence to malevolence simply by changing their policies from day to day. Nothing more needs to be done. The very same bureaucratic personnel, facilities, machinery, and powers are available and capable of being applied to malign ends. More than that, administrative agencies have not only absorbed in tyrannical form many of the mere legislative, executive, and judicial powers that we, the people, originally delegated to the general government, but in addition, they have arrogated to themselves something far beyond those powers, namely a large measure of the people's fundamental sovereign authority itself. Now recall the supposed reason for setting up administrative agencies in the first place. According to the proponents of the administrative state, America needs this fourth branch of government, which is largely independent of Congress. The agencies are to be non-political so that they can exercise their expertise without undue influence and interference arising out of irrelevant political pressure. But because the purpose and effect of creating independent and non-political agencies is to insulate the matters assigned to those agencies from effective political control by Congress, and because Congress itself is subject to political control by we the people, supposedly, in the final analysis, the purpose and effect of creating independent and non-political administrative agencies is to remove these matters from significant control by we the people too. Or should I say, from significant control by we the people especially. All right? We are the targets of this, you and I. Now, this is hardly accidental. It's not an unintended consequence of the creation and operation of these agencies. It's the essence of the process. After all, by hypothesis, the bureaucrats who staff the agencies are selected precisely because of their supposed abilities to deal with these special matters assigned to them as the result of their highly specialized education and training and experience, etc. By hypothesis, these professional experts always know better than ordinary laymen. Therefore, they know when to disregard the mundane desires of the people and to act contrary to and even in defiance of those desires. For in contrast to experts who can be expected to remain steadfast in pursuit of their thoroughly thought out policies over the years, the people are mercurial in temperament. They're devoid of the necessary technical knowledge. And they're prone to fits of political enthusiasm or hysteria. Right? We know the way people are. Right? Chronic interference by the people through regular elected representatives who attempt to inject the people's ever-changing and often simplistic ideas into the workings of the agencies can only interfere and predictably frustrate the experts who are attempting to plan on a long-term basis. In an increasingly complex society, this sort of amateurism simply cannot be tolerated. So it must be understood that Congress's responsibility is to enact statutes which delegate vast areas of authority to administrative agencies, and then to see to it that the agencies always receive adequate perpetual funding. And we, the people's function, is simply to elect dummy representatives who mechanically accomplish these tasks. Thus, the purpose of the modern political process of representative government and of we, the people's participation in that process is to conduct a charade. In the guise of representative government, we create, empower, and equip the agencies with whatever the agencies want, and otherwise we stay out of the experts' way in the determination and enforcement of public policy. We, the people, are never, by any means, actually to control the agencies. Rather, the agencies are, by whatever means they can muster, to control the people. For the people's good, of course. We have to understand that. All right. Well, in their constant harping on the value of delegating governmental authority to independent, non-political administrative agencies, the partisans of the administrative state tend to overlook several points. First, all of the general government's branches and the position of every public official are inherently political, simply because those branches and officials are the creatures of and are entirely dependent upon and subservient to the people's political sovereignty. Therefore, they are always required to perform all of their functions according, in the final analysis, to political supervision and criteria, which can be enforced in one way or another by the people, either at the polls or perhaps through the process of impeachment or whatever. Criminal prosecution, that's my favorite, but we won't talk about that. Second, by delegating in the Constitution certain powers to Congress, which is, of course, the quintessentially political branch of the general government, we, the people, demonstrated that they desired those powers to be exercised according to political criteria. And that exercise should be subject to political checks and balances of representative government, which the Constitution also requires. And in contrast to this, well, the independent, non-political administrative agencies must be, or they must aspire to be, and they certainly act as if they were, independent of we, the people's political sovereignty within those areas in which the agencies operate. Well, sovereignty can never be in abeyance. Right? Someone always has to exercise it. If, whether directly or through representatives elected on a regular basis or in some other manner, we, the people, do not exercise their sovereignty over those areas of governmental activity assigned to various agencies, then the agencies must exercise sovereignty there. Well, needless to say, this result contradicts the essence not only of the Constitution, but of the Declaration of Independence. Well, so much for the definition of tyranny applicable to administrative agencies in principle. Tyranny also has a very practical definition that's applicable to them. Going back to Locke, section 199 of his second treatise, he defined tyranny as the exercise of power beyond right, which no body can have a right to. And this is the making use of the power anyone has in his hands, not for the good of those who are under it, but for his own private special advantage. And in section 201 of that same work, Locke explained that 'tis a mistake to think this fault is proper only to monarchies. Other forms of government are liable to it. For wherever the power that is put in any hands for the government of the people and the preservation of their properties is applied to other ends and made use to impoverish, harass, or subdue them to the arbitrary and irregular commands of those that have it, there it presently becomes tyranny, whether those that use it are one or many. Later on in Federalist Number 10, very famous passage, James Madison described a faction as comprising, quote, a number of citizens, whether amounting to a majority or minority of the whole, who are united and actuated by some common impulse of passion or of interest, adverse to the rights of other citizens or to the permanent and aggregate interests of the community. So you combine those two. Public officials and public institutions must be condemned as tyrannical when in fact they impoverish, harass, or subdue the people to arbitrary and irregular commands in order to serve the interests of factions adverse to the rights of other citizens or to the permanent and aggregate interests of the community. And these factions may consist of rogue public officials or of citizens who collude with such officials in order to obtain special benefits or advantages to the detriment of the community as a whole. Sounds like a description of Washington, D.C. right now. Right? Well, especially in its reference to to the purposes of providing for the common defense and promoting the general welfare, the Constitution, in its preamble, emphasizes precisely that the general government is powerless to expend and extend special favors to factions, whether in individual cases or by creating institutions that are set up for that particular purpose. And so important is this principle that the Constitution repeats it in Article 1, Section 8, Clause 1, namely, Congress shall have the power to lay and collect taxes, to pay the debts and provide for the common defense and general welfare of the United States, and for nothing else. All right? Thus, the Constitution denies Congress the authority either to raise or spend money for purposes which are adverse to the permanent and aggregate interests of the community. So Congress cannot finance agencies which themselves act as or which promote the special interests of factions. And if Congress cannot finance the operations of such agencies, it can hardly claim a power to create them in the first place. Seems like this is another one of those constitutional circles. Now, on the one hand, administrative agencies would qualify as factions when they were truly independent, not only of Congress and we the people, but of all other private special interest groups. And when they exercised this independence in the personal interests of the expert professional bureaucrats who ran them, but in a manner adverse to the permanent and aggregate interests of the community. You think there are agencies that do that today? Try the Environmental Protection Agency. Try the IRS. You want to run down some lists? We could spend an hour listing these agencies that fall into that category. Right? In that case, if, as is usually the situation, the bureaucrats were putting into practice some economic or political ideology that called for government planning of society, and usually that's their rationale, where we're planning something for you, the administrative state could be likened to a particularly malignant form of socialism. That's one possibility. That's not representative Republican government, but it's what is there. If, on the other hand, the agencies serve various private factions, such as large corporate interests, the administrative state could be likened to a form of corporatism or fascism in the Italian sense. All right? In this particular case, an agency might be created for the very purpose of advancing the parochial interests of some particular businesses in certain segments of the economy. Think of the Federal Reserve Board and the Federal Reserve Act of 1913. Why was that created? For the banking interests. And they said it at the time. Right? They were very upfront, as it were, with that. Or the National Recovery Administration under the National Industrial Recovery Act of 1913. That was set up with respect to various parts of American industry in general, cartelization of American industry as Roosevelt's first attempt to defeat the Depression. So we have seen this in American law. The National Industrial Recovery Act is gone, but the Federal Reserve Act is still with us. To regulate some segment of the economy in the public interest might, in the course of time, be politically captured. That's the word. The agency would be captured by the businesses it was supposed to supervise, and thereafter would regulate those businesses in the business special interest, quite in disregard of the public interest. And I think one would conclude the Food and Drug Administration is probably a good example of that, where whatever the purity of the origins of that agency, it has subsequently been captured by the big pharmaceutical companies. All right? Now, of course, none of this should be surprising to students of criminal politics. Right. Because all governments which the people do not strictly control tend to factionalism in purpose and then to tyranny in form. Why? Factions always promote tyranny because tyranny provides the surest support for factionalism. Tyrants will always support factionalism under the principle of divide and rule. These things work together like the iron hand in the iron glove. Well, the consequences of Congress's creation of the administrative state, with all of these delegations to agencies of great swaths of legislative power, I would say in principle are rather frightening, and probably they will become more frightening in practice. We go back to Locke, section 227 of the Second Treatise. When either the legislature is changed or the legislators act contrary to the end for which they were constituted, those who are guilty of rebellion. For if anyone by force takes away the established legislature of any society and the laws made by them pursuant to their trust, he thereby takes away the umpirage which every one had consented to for a peaceable decision of all their controversies, and a bar to the state of war amongst them. They who remove or change the legislative take away this decisive power, which nobody can have but by the appointment and consent of the people, and so destroying the authority which the people did and nobody else can set up, and introducing a power which the people hath not authorized, they actually introduce a state of war, which is that of force without authority. All right? That's the ultimate consequence of the breakdown of the forms, which the Declaration of Independence told us, right, when the forms of government were changed illegally. Right? Okay. This may be a state of Cold War at the present time, but it's a state of war nonetheless, and I would suggest it's going to become quite a bit warmer when the Federal Reserve System melts down in the not-so-distant future. We see one of the effects of one of the major agencies on the entire country. Well, what's the final word here? I would say it's really simple. No possibility of compromise exists in this situation. Neither the Constitution nor the Declaration of Independence can coexist with the administrative state. But whether we, the people, will recognize this antagonism, and more importantly, will steel themselves to take the necessary corrective steps, still remains to be seen. Thank you, ladies and gentlemen.
Grog TV.